Professor Piejetua, you will respond. Let me bring him. You will respond. Professor Piejetua is a professor of law at the University of Ghana School of Law. And a quick one, Professor Piejetua, first of all, let's establish this. I mean, does the plea bargaining process, as established in law, include, for instance, the accused person being asked to help make a case against another accused person by the prosecution?
Well, based on what the third accused is saying, there seems to be something which is odd about the whole process because, like I said initially, it's not supposed to be imposed. It is, that's why it's called a bargain. It's like going to the market to bargain for the price of a container of tomatoes or something. So it should be at the free will of either party. One cannot impose on the other. And so if it is the Attorney General that is suggesting for a plea bargain, it should come freely from the accused person to accept it. And then they negotiate the terms. There are different aspects of the free bargaining process. It could relate to the sentencing, it could relate to the charges, it could relate to the costs involved, it could relate to, for example, how much the accused person is ready to pay as compensation to the victim involved in the case, a number of factors. So all those things, the two parties will need to agree on. Sometimes, in most cases, involving their lawyers. And then they argue and they make a case that this is what I will lose. It's a kind of risk-taking as well. So you look at the advantage of going full trial and what you would lose or what you might lose if you go on a full trial. And then you go for a reduced trial, but you're losing something. And if you put everything in the bag together, you realize that at the end of the day, I'm better off not going full trial, even if I may lose some rights. And by looking at the bigger picture, I'm better off. You spend less time in the courtroom, you're able to save some time for some other activity. And so at the end of the day, you say, I'll go for it this way. So if it is being imposed, then it becomes a problem. It loses the idea of bargaining. And if you look at the Act, it doesn't accept that or recognize some imposition in this whole bargaining process.
No, you talk about imposition there, and that leads me to the specific quote attributed to Richard Jakpa, which has not been disputed, that the Attorney General on several occasions engaged him at odd hours to help him make a case against the first accused. This was not part of the plea bargaining. And as you have indicated, it is not part of the plea bargaining process. And it continues that if he pushes me, I will open the Pandora's box. I don't understand why the Attorney General will accuse me. It goes on and on. Now, that particular statement, which you have read and seen as well, does that raise any concerns for you from where you sit?
No, I don't think that is part of a plea bargaining process, because here you are trying to make the other person support the case of the other person. In the plea bargaining, yes, you can bargain that, okay, here's a case where the main fish, if you like, in the case is one particular accused person. And if we're able to find him guilty, it will make our case stronger. As for the other parties, they are lesser or smaller fishes, if you like. Let me use that word. So the evidence that the other parties can give, you say that, okay, we will give you a lesser punishment if you testify against this person, or if you not provide some other reason or some other issues that if you don't present them, it will make the case stronger against another in any of the other parties involved as accused persons in the case. So, but this is not imposed. This is something that can be a bargaining chip that can be used to get a lesser sentence for the third party, or the other, in this case, the third party. But it is not something that should be imposed. Now, but looking at the whole scenario based on the facts of what we have heard, we don't know the details. But according to what is in the news, it is rather and I think even Attorney General confirmed that it's the third party that initiated the plea bargain. If that is the case, then there is no way the Attorney General should take advantage of that to ask the third party to testify against the other party by way of imposition. Because if that is the case, and probably that is why the NDC, the third party in the case, made the court record it. Because if that happens to be the case, and then the plea bargaining is struck and judgment is given, but later on it is found out that the bargain was achieved through some arm twisting and so on, the court can nullify the whole process. So
I see.
It is not part of the plea bargaining process.
Right.
Trying to arm twist somebody, trying to push somebody to the wall is certainly not a bargaining process. It should be a free negotiating process, which at the end of the day should benefit.
It's a very instructive statement that you made in the end there, but where an accused person makes such allegations, Prof, against a prosecution during cross-examination in open court, and it is not contested by the prosecution, I mean, how will the court be required to treat a statement like this allegation?
Well, first of all, it is noted by the court, and if it becomes necessary that it will affect the outcome of the case in any way, then evidence could be called to confirm or to ascertain the facts and to know what really happened. And if that is the case, in this context with respect to the plea bargaining, the whole process, the whole plea bargaining thing can collapse, and normal due process will follow. And so that is what the court will do.
Thank you. Thank you very much for your input on this. Professor Appiah Etia is a professor of law, even an associate professor of law at the University of Ghana School of Law. They're also making very instructive statements in this regard. Thank you very much for this input. And I would come to you, Honorable Chinia, because Lawyer Martin Kpebu, that's that same question of how this allegation that is not contested would impact on the case going forward. There's been suggestions that either the Attorney General should recuse himself, others say that, look, the veracity of this case, if so established, could lead to a mistrial. Is it one that can happen because of this statement, this allegation that was not contested in open court by the Attorney General?
Oh, yes. Yes, so the court has inherent jurisdiction, right, to stop the trial, okay, discontinue it, once the court finds that its processes, that's this prosecution, is being abused, is being used for a political vendetta. So meaning that if once it's established that the Attorney General had no basis for coming to court, but just initiated this particular prosecution in order to muscle Atuforsen, you see, in order to shut him down, then the court can stop the trial. Because you see, one thing that, especially if you add it to the fact that Big C had said, give us the ambulances, we will pay you back. So why are we in court? So if you look at it, once the tapes come out, it shows that the Attorney General was really suborning the witness. Oh, this case will have to be discontinued because we don't allow it. It's not allowed. You can't use the court processes for vengeance. You don't use it to muscle political opponents. No, that's what we call abuse of process. If we find that, that would be tantamount to abuse of process of the court. using it to witch hunt political opponents. That's not what the law is for. You see, and especially if you look at it, I'm tending to be on the side of Jakpa, though ultimately is the tapes that would resolve everything. Because, you see, in the past, there is an Attorney General who added ACP Dr. Benjamin Agbojo to the treason trial when he himself had no basis. And he told me, and Agbojo was standing there, that, oh, we just added him. Just added him so that the case will look credible. And destroyed an assistant commissioner.
He said that to you?
Yes. Agbojo was standing there. That's my luck. So it's not like I had to go in. He was standing behind me when Dami said it. Move, you come to Cecilia Dapa on Saturday, 4th May.
For malicious prosecution.
We are looking at that. Okay. On Saturday, 4th May, what did Dami do? He went on Joy FM and lied about Cecilia Dapa's case, said that Mamiti Wadu Dankwa had conducted thorough investigations and found nothing. Meanwhile, your own letter that you instructed Evel Kilson to write, you said Yoko was here to commence investigations. So if you add this attempt to free Cecilia Dapa, what you did to ACP Dr. Benjamin Agbojo, okay, I'm tending to go with Jakpa, though I will hold my horses and wait for the tapes. But Dami, no. Dami has
okay. So